And now, the last word with Rick Casey.
When Attorney General Greg Abbott filed a motion to remove the judge presiding over the latest and most massive lawsuit challenging Texas's school finance system, I was glad San Antonio Judge David Peoples was chosen to preside over the controversy. Peoples earned a reputation as thoughtful and fair during 27 years as a district judge, an appeals judge, and as presiding judge of a region covering 22 South Texas counties. Peoples is a Republican, appointed to positions by both Governor George Bush and Governor Rick Perry, but he is regarded, as a judge should be, as more devoted to the law than to his party. Attorney General Abbott, a Republican running for governor, charged that Austin District Judge John Dietz, a Democrat, should be removed from the school finance case because he had secretly coached attorneys for the 600 school districts who were suing the state. Abbott said the coaching came through emails that were not shared with the Attorney General's office. And that sounds very bad. Judges are generally required to include both sides of a controversy in conversations about a case. But after hearing arguments from both sides and examining the trial record and the emails, Peoples found reality to be somewhat different. It is common in Texas courts for judges at the end of a trial to ask prevailing parties to draft an order describing findings of fact and conclusions of law. Judge Dietz proposed a different system. He asked the various parties, the Attorney General and several separate groups of school districts, to prepare findings of facts and conclusions of law as the trial progressed. He promised not to show the submissions to the other side during the trial. Dietz said this would help keep lawyers from wandering off into non-related areas as they dealt with various issues of the Byzantine funding system, and it would shorten the time between the closing of evidence and the issuance of a final order. Dietz presented the plan at a public hearing at the beginning of the trial, and both sides agreed. The first phase of the trial ended in February 2013. Dietz then found the funding system to violate the Texas Constitution, but he delayed issuing a final order to see what last year's legislature would do. When they restored $3.9 billion of the $5.4 billion they had cut from schools 2 years earlier and cut back on the number of tests students would take, Dietz reopened the trial. According to Judge Peoples' order, Dietz told all the attorneys in writing in December that he intended to follow those same procedures. No one objected. Peoples did note that the Attorney General was reasonably surprised by the amount of correspondence between Judge Dietz and school district lawyers. Peoples said it would have been better had both sides been more clearly informed that there would be some back and forth. But he said the issue wasn't whether the judge's system was ideal, it was whether it indicated bias, and Peoples found none. Now, Abbott may appeal, and if he does and wins, a final ruling may be delayed for a year or two by a new trial before inevitably going to the Texas Supreme Court. Now, a footnote, this isn't the first time Dietz and Abbott have clashed. In 1996, Dietz issued an injunction barring the Republican Party from keeping the Log Cabin Republicans, a gay group, from advertising in its convention program or having a booth at the convention. Abbott, then a Supreme Court justice, wrote the majority opinion overruling Dietz. The Republican Party relied on that decision this month to again bar the Log Cabin Republicans from erecting a booth or advertising at the party's Fort Worth convention. Republican State Chairman Steve Monasteri said it was not because they were gay, but, quote, because of the association with the promotion for gay marriage, which is not supported in the current party platform. But the John Birch Society was allowed to have a booth. Does this mean all Bircher positions are supported by the Republican platform? And that's it for Texas Week. See you next time.